Welcome back. If you have not had an opportunity to view my initial video on Kilmar Garcia, please go view. He was protected by U.S. law. Then ICE sent him to hell. Great news, there is an updated to the case of Kilmar Garcia, the Maryland father who in essence was kidnapped and illegally deported from the U.S. to El Salvador, Cecot. Despite the court order issued on the 9th of November, 2019, the voices penetrated the silence of injustice, and the court has ruled in his favor.
A Maryland immigrant mistakenly deported to an El Salvador prison.
7 News Maryland Bureau Chief Brad Bell was in the courtroom and just heard from the wife of the man who was deported. An emotional day, Brad.
Yeah, look, this is an extraordinary case. We've been talking about it this week. This man had lived here for quite a few years. He had no criminal history, but he was picked up by ICE. And then, in spite of a judge's order saying that he should not be deported to El Salvador, he was sent to that prison that we've all seen on TV with those men bent over and walked into a cell. The family got lawyers, they fought, and today, victory. Supporters rallied outside the U.S. District Court in Greenbelt as inside a Department of Justice attorney admitted to Judge Paula Zinnes that there was no legal basis for the arrest and deportation of Wilmar Garcia. He further admitted that he had no answer as to why the Beltsville resident was being held in the notorious El Salvadoran prison with others deported by the Trump administration. The judge quickly ordering the man returned to the U.S. by midnight Monday, a victory for Garcia's wife, who emerged from the courthouse to cheers.
I want to say thank you to everyone that has helped us, that has supported us in fighting this, and we will continue fighting for Kilmar, for my husband.
Yeah, so she only had a few words earlier today. We got to talk to her at greater length. She said her family's life has been completely upended. Her children don't understand it. They try to communicate with on their tablet with their father. Of course, no luck there. Now, the next question is, will the federal government obey? We have not gotten any word on that at all. I will say that the lawyer that was in here representing the Trump administration, a longtime Department of Justice lawyer, actually admitted to the judge it's going to be frustrating because he said, I don't have a lot of answers for your questions when the judge was asking about the status of Wilmar and why he was being held. And he said it was actually his advice to his client, and that is the Trump administration, to bring the man back to the country. We're going to be back at 6 with much more on this case. In Greenbelt, Brad Bell, 7 News.
When I first heard of this story, it pierced the core of my soul. As a former law enforcement officer of 15 years with the highest rank of captain, I led the gang task force and was the primary and expert law enforcement officer in the jurisdiction responsible for validating gang members, by which they had to have 3 or more of the qualifiers to be classified as a gang member. I was always acutely aware of due process and never in my tenure had any accusations of violations of abuse of power or violating one's rights. It still baffles me that people have this misconception that due process is tied to one's legal status in this America. Let's be clear. Everyone who is in these United States is entitled to due process. Due process is not tied to your legal status or illegal status, citizen or non-citizen, or how you entered into these United States. The Fifth Amendment says the federal government cannot deprive any person of life, liberty, or property without due process of law. The 14th Amendment says state governments cannot deprive any person of life, liberty, or property without due process of law. As his wife and activists beefed up protest and pushed his story, the Trump administration went from this Maryland father was a MS-13 gang member who, I must add, there was no evidence to substantiate the claim in a court of law in 2019 to claim he was a human trafficker. When asked for evidence of this, well, let's just listen, and then we will highlight the court transcripts.
The administration has expressed a complete confidence in how all the deportation flights to El Salvador were conducted. But now that the administration has conceded that there was an error of one Salvadoran national, will there be any reviews conducted? And does the president express any thoughts on the one error that was disclosed in court last night?
Well, first of all, the error that you are referring to was a clerical error. It was an administrative error. The administration maintains the position that this individual who was deported to El Salvador and will not be returning to our country was a member of the brutal and vicious MS-13 gang. That is fact number one. Fact number two, we also have credible intelligence proving that this individual was involved in human trafficking. And fact number three, this individual was a member, actually a leader of the brutal MS-13 gang, which this president has designated as a foreign terrorist organization. Fact number four is that foreign terrorists do not have legal protections in the United States of America anymore. And it is within the president's executive authority and power to deport these heinous individuals from American communities. It is a promise he campaigned on. It is a promise he is keeping. And every single person in this room should be grateful for that, considering especially MS-13 is very prevalent and prominent here in the District of Columbia, in Maryland, and in Virginia. And the president, the attorney general, everyone who has been involved in these operations is focused on eradicating these criminals and terrorists from our communities.
The vice president said he was a convicted member of MS-13. What evidence is there to back that up?
There's a lot of evidence, and the Department of Homeland Security and ICE have that evidence, and I saw it this morning.
Carolyn, a few questions about this deportation case. First, I wanted to clarify something that you said to Jeff a few minutes ago. You said you'd seen evidence that this man was a convicted gang member. In what court was he convicted, and for what?
This individual was an MS-13 ringleader. This individual was also engaged in human trafficking. And I'm glad you brought up this point again, because I would like to point out that if you just saw the headline from the insane, failing Atlantic magazine this morning, you would think this individual was Father of the Year, living in Maryland, living a peaceful life, when that couldn't be further from the truth. They didn't even mention in the title of that article, or even in the first paragraph, that this individual is an illegal criminal who broke our nation's immigration laws. He is a leader in the brutal MS-13 gang, and he is involved in human trafficking, and now MS-13 is a designated foreign terrorist organization. Foreign terrorists have no legal protections in the United States of America, and this administration is going to continue to deport foreign terrorists and illegal criminals from our nation's interior.
But a judge ordered that he should remain in this country. So are you saying that it is okay to ignore a judge's ruling if you don't like it?
Who does that judge work for?
He's an immigration
It was an
judge.
immigration judge who works for the Department of Justice at the direction of the Attorney General of the United States, whose name is Pam Bondi, who has committed to eradicating MS-13 from our nation's interior.
A few excerpts from the court transcripts. There has been a plethora of filings, way too many to display. However, there is not a single court transcript that speaks to any evidence that proves that Kilmar is a MS-13 gang member, or mention or proves this new slanderous accusation with him being a human trafficker. Plaintiffs allege that on the 12th of March 2025, Abrego Garcia was stopped by ICE officers who informed him that his immigration status had changed. After being detained, he was questioned about gang affiliations and transferred ultimately to a detention center in Texas. Plaintiffs allege Abrego Garcia was told he would be removed to El Salvador and detained at the Cecot prison there. On the 15th of March 2025, although ICE was aware of his protection from removal to El Salvador, Abrego Garcia was removed to El Salvador because of an administrative error. So let me put this into real everyday scenario. They had no reasonable suspicion to stop the vehicle, no probable cause to detain, arrest, or deport to El Salvador, and to add, they knew he was not to be deported to El Salvador. On the 16th of March 2025, a news article contained a photograph of individuals entering intake at Cecot. Abrego Garcia's wife identified one of the detainees depicted as her husband based on his tattoos and headscars. Plaintiffs allege, based on a news article, that the federal government has paid, or continues to pay, the government of El Salvador $6 million in order for the government of El Salvador to detain individuals removed there from the United States, including plaintiff Abrego Garcia. Please explain to the general public, why is it that in the midst of all these court filings and transcripts and the Department of Justice getting hammered by every corner from various federal judges to public scrutiny, they have not provided that discovery information to the judges, but only allowed it to be viewed by the press secretary Caroline Levitt, if you remember what she said at the podium. A person who has no judicial acumen or rulings. It's simple, there is no evidence. Let's go a bit deeper. Their Department of Justice lawyer, Erez Ruvini, who was given the case file to argue in federal court, was not privy to this so-called evidence. Now, even in traffic court, lawyers are prepared with some evidence. And here we are with an administration that only hires the best of the best, yet send lawyers into federal court without providing them with discoverable evidence as to why the individual was classified as not only as a gang member, but as a human trafficker and deported to El Salvador, but allows the press secretary to see the evidence. Stop drinking the orange Kool-Aid, people. Bear with me here, it's important to follow this last part. As a matter of law, withholding of removal prohibits DHS, which is Department of Homeland Security, from returning an alien to the specific country in which he fears clear probability of persecution. In Abrego Garcia's case, the IJ, immigration judge concluded that he was entitled to such protection because the Barrio 18 gang had been targeting him and threatening him with death because of his family's pupusa business. DHS never appealed, and it became final the 9th of November 2019. There is no dispute that the order could not be used to send Mr. Abrego Garcia to El Salvador. Neither the United States nor El Salvador have told anyone why he was returned to the very country to which he cannot return, or why he is detained at Cecot. Mr. Ruveni responds, "We have nothing to say on the merits. We concede he should not have been removed to El Salvador." The court asks, "What basis is he held? Why is he in Cecot of all places?" Mr. Ruveni responds, "I don't know. The information has not been given to me. I don't know," the silence is telling. As defendants acknowledge, they had no legal authority to arrest him, no justification to detain him, and no grounds to send him to El Salvador, let alone deliver him into one of the most dangerous prisons in the Western Hemisphere. Having confessed grievous error, the defendants now argues that this court lacks the power to hear this case, and they lack the power to order Abrego Garcia's return. Just let that sit on your soul for a moment. What if this was your husband, your brother, your uncle, your cousin, your friend, your neighbor, someone you cared about, and this happened to them? It is happening to others. It is becoming more apparent why the names of those deported are not being released. They are citing states' secrets privilege doctrine, first used in 1953 in a case called U.S. versus Reynolds. This is not an isolated case. Far from it. The judge coined this wholly lawless. I say that we are all on set, 78 days in, of the filming of the first 47, where we watching the automatic designation of persons as gang members by tattoos in the first 30 minutes, without any other qualifiers, being processed in 24 hours and have them shipped to Cecot within 47 hours without due process. If lives were not at stake, this would be comical. But lives are involved, and violations of constitutional rights are no laughing matter. For those in the judicial sphere who choose to lie and fall on the sword for Trump, let the fall from grace of Rudy Giuliani be a warning. There is not enough power or money that can make an ethical person compromise their integrity. I often say that money does not change a person. It reveals who they are. Power and position works the same. And everyone in Trump's cabinet, we know who they are. The wheels of justice theoretically turn slow in most cases, but I can assure you there will be a long list of lawyers whose names will be recorded in history as having their bar license revoked. Justice will prevail. This story is fluid. I was hoping to post a positive story. To date, we have had 2 trial court orders, a decision by the 4th Circuit Court of Appeals, and today an administrative stay by Justice Roberts. We will continue to push for Kilmar safe return. Remember, silence protects no one. We must continue to demand action, demand accountability. Stand up, speak up, and let the echoes of freedom break the silence.